So in today's video, we'll look at Unit 11 of the Law of Torts, which is liability for animals. Since an animal is considered to be property under the law of tort holds the owners of the animal strictly liable for the injuries caused by their animals. This is partly because it's impossible to sue an animal for the injury they've caused. So instead, we sue the owner. So liability for action in the law of tort is classified into two. We have scienter action and animal trespass. So under scienter action, so scienter is I don't know if I'm pronouncing it right, but yeah, it's a Latin term meaning knowledge or awareness. So scienter action refers to a legal claim where an injured party seeks to hold an animal's owner liable for the harm caused by the animal. So based on the owner's knowledge of the animal's dangerous tendencies. So under this branch of tort, we have two types of animals. There's animals that are dangerous by nature and animals that are dangerous when provoked. Animals which are considered dangerous by nature include things like lions, tigers, and elephants. So under this branch or this class of animals, liability is strict on the owner in order to ensure that it does not cause mischief, and as such, he or she who keeps dangerous animals does so at his peril. So peril here means any risk or danger that could harm an individual's property or interest. Under this class of animals, it is irrelevant if the animal is tamed or not, or whether it was acting out of fright. Yeah, as long as it has caused damage, you'll be held strictly liable for the damage the animal has caused. As was seen in the case of Beren versus Bertram Sekes. So the brief facts of this case were that the defendant had granted the plaintiff a license to have them work at the defendant's circus. So the defendant had forbade the plaintiffs from bringing dogs, but the plaintiff's husband ignored the prohibition and brought his dog to the circus. So the dog barked at one of the defendant's trained elephants, which began to chase the dog. Consequently, the elephant injured the plaintiff and damaged her both. So the court here ruled in favor of the plaintiff and stated that the owners of an animal considered wild, even if tame and trained, is strictly liable for any damage it may cause when it is out of the owner's control. So now that we have looked at animals that are considered wild by nature, we'll now look at animals that are not considered wild in nature. Such animals like dogs, for example. So here, liability only arises if the owner of the animal had previous knowledge of the dangerous behavior of the animal. Therefore, the plaintiff has to only prove that the animal had a vicious tendency and the owner was aware of this tendency, as was seen in the case of Kaoma v. Palmer. So now we can look at the defenses. So we have four defenses here. The first one is fault of the victim. So under this defense, the keeper will not be liable where the damage suffered is due wholly to the fault of the person suffering it. For example, the claimant is bitten by a dog he has just kicked or provoked. The second is voluntary acceptance of risk. For example, a person who tries to escape despite being warned that if he does, the police dog will be released on him. And the third defense is if the victim is a trespasser. So this was seen in the case of Cummings versus Granger, where an untrained dog was turned loose in a scrapyard to deter intruders. So the dog had seriously injured the plaintiff who had entered the scrapyard. So in this case, the defendant was entitled to rely upon the trespass defense provided. And the fourth and final defense is contributory negligence on the part of the plaintiff. So this refers to a situation where the injured party's own negligence contributed to their injury caused by the animal. Apart from scienter, there are other special rules relating to animal liability. So this is known as cattle trespass. So here, the owner is strictly liable for the damage caused by his trespassing cattle. So there's a difference between cattle trespass and personal trespass, which one can commit through one's animals. Let's say, for example, a person's cattle stray from his land and go onto the land of another, this is called cattle trespass. But if the person drives his cattle or deposits them onto another's land, this is not cattle trespass, but trespass to land committed via the instrumentality of his animals. So I feel like the distinction between the two, between cattle trespass and personal trespass, is that in cattle trespass, the owner is not aware that his cattle are moving to the other's land. But in the personal trespass, he's aware and is encouraging the animals or driving the animals into the other person's land. Alright, so that's all we'll talk about under this unit. It's a really short unit, and there are only 3 cases, which is Beren versus Bertram Milsekes and Kalma v. Palmer and Cummings versus Granger. So if you know these cases, then you'll be alright for this unit.